Civics Chapter 7, Section 2, the organization of the federal courts. As we discussed in the previous chapter, the federal court system of the judicial branch has three levels: the district courts, the appellate courts, and the Supreme Court. And there are 94 district courts. That's the base level of the judicial branch. That's usually the level of jurisdiction. So there are over 670 district judges in these 94 district courts. And the larger the district, the more judges a district court needs. Some smaller district courts only have one judge. So anyways, the district judge lives in the district that they serve in. They're appointed by the President of the United States, and they serve for a lifetime with good behavior. Most federal cases start at the district court level. Like I said, that's the place of original jurisdiction, is mainly at the district court level. There's about 300,000 federal district court cases every single year, so there's a lot of cases happen, a lot of trials. And district courts hear cases that are both civil and criminal. Civil meaning no one's going to go to jail, but it's about money or property, like getting sued or something like that. Criminal is like you broke a law. So in Pennsylvania, we're divided into three separate districts. You have the Eastern, where Philadelphia is, Middle District, Harrisburg, our state capital, Williamsburg, Scranton, and then you have the Western District, which is where we are, which has Pittsburgh, Johnstown, and Erie. And Pittsburgh, Johnstown, and Erie is where our district courts are. So if you're ever brought in for federal court, hopefully not, you're probably going to go to Pittsburgh. So that's our closest one to us. And there's 20 judges in the Western District of Pennsylvania. So, federal court system. The federal district courts, that's where the trials happen. The judge delivers a ruling. That's an authoritarian decision. Then the jury delivers a verdict, decision made by the jury. And if the plaintiff or defendant does not agree with this, it goes on to the next level, which it goes to the Federal Court of Appeals. So that's the beauty of the American judicial system, is that if you think that you've been wronged in a trial, it's not like that's it, nothing you can do. You can go to the Court of Appeals, appeal your case. And at the Federal Court of Appeals, this handles the appeals from multiple districts. So there are 12 courts of appeal in the United States. So we're Pennsylvania, we're in the third, and you can see all the districts. We're lumped in with Delaware, New Jersey, Pennsylvania. So all the appeals of all the federal court cases in the district courts go to this one federal court of appeals. And this area that we call, this district, it's not actually a district, it's called a circuit. This conglomeration of districts, that's a circuit. So a lot of times, therefore, the Court of Appeals are called circuit courts. The circuit court or Court of Appeals does not have a jury. There's no witnesses, does not examine evidence. Really, there's just three judges, and they review everything from what happened in the district court. Lawyers and defendants, they do present their case to the three judges. They each get a chance to speak, present their case. They look at everything that happened, look at the ruling, and these three judges decide whether the court case was fair in the district courts, or that there needs to be another trial. The Court of Appeals does not consider guilt or innocence. It just affirms or says that maybe the trial should be looked at again. So that's what the Court of Appeals does. They don't change the verdict. They just say, well, the decision was fair, or this needs to be looked at again because the proceedings was not entirely constitutional. The Supreme Court is the highest court in the United States. It hears the appeals from both the state and federal levels. So the Supreme goes district court, appellate court, the circuit courts, and then it goes to the Supreme Court. So the Supreme Court gives the final ruling on all cases. There's 9 judges. They're called justices. We've gone over this before. The head of the Supreme Court is the Chief Justice. The current one is Chief Justice John Roberts. He was appointed by President George W. Bush. And really, a Chief Justice does not have to have served on the Supreme Court before, like Chief Justice John Roberts. He happened just to be the former Chief Justice died, and he was the next one to be sworn in, and they thought that the president thought he would be a good Chief Justice, and he's been in the position about 15 years now. All Supreme Court justices are selected by the president and then approved by the Senate, and they serve a lifetime. Here's our current Supreme Court. So these are all the nominated, the justices nominated by by a Republican president, and these 3, Gorsuch, Kavanaugh, and Coney Barrett, were all nominated by President Trump. So cases that move through different levels of the court system. A case starts in the district level, and then a decision is issued. If someone doesn't like it, either the defendant or the plaintiff, they can appeal, and it goes to the circuit court, which is the Court of Appeals. The circuit court then issues a decision whether the trial was fair or not, and after that, there's multiple places where it can go. It can be sent. This case can be sent back to the district court. The end decision of the circuit court, it could be just end there. The circuit court could affirm that the district court decision was fair, and then it doesn't really go anywhere, and then it could just end there if no one presses the subject. Or one of the parties could appeal directly to the Supreme Court, appeal their case even further from the Court of Appeals. And that's when it goes to the Supreme Court. It's really hard to get your case to the Supreme Court. A person, if you want to appeal their case after going to the circuit courts, you have to file a writ of certiorari, and that just means it's a document to seek judicial review of a decision of a lower court in government. The Supreme Court sees thousands of these a year, and if 4 of the 9 Supreme Court justices agree to hear this case, the court will issue the writ of certiorari and allows the case to proceed. If less than 4 justices agree to see the case, then it's said that the case is denied cert, and the ruling of the lower court is final. The Supreme Court's not going to see it, so whatever the appellate court said, that's the final ruling on it. The court issues the writ of certiorari. The Supreme Court will hear arguments from both parties and then issue a decision. At the Supreme Court level, there's no trial. There's just both parties present their case. The decision is based on the majority opinion of the Supreme Court. So to get a majority of the Supreme Court, you need 5 out of 9 justices. It's good to have an odd amount, so there's always a majority. So at the end of Supreme Court ruling, the judges of both the majority and minority party give their opinion. An opinion is an explanation of the court's judgment and reasonings for their ruling. So you can read these. They're kind of long and boring about all these cases online by a member of the majority party. So if you're at 1 out of the 5, they give their majority opinion, why they ruled the way they did, and then the minority people ruled why they voted the way they did on the case. Cases can get voted unanimously. That means that all 9 judges could have agreed on a case. It happens. And the Supreme Court decision is final. There's nowhere else to go after the Supreme Court. So if you don't like this decision at the Supreme Court, it's over. And then a separate court case would need to be established before a law may be declared unconstitutional. So if you don't like a law, like some kind of gun rights law or something like that, on a certain situation, because all the cases that come to the Supreme Court at any court level are very specific cases, and they're based off a precedent or what they feel at the time. Another case about that same law needs to happen for that law to be changed, or something like that to be unconstitutional. So it takes some time. Like it took 70 years for the separate but equal laws in the South to be changed. Originally, it was late 1800s. The separate but equal laws were held up by the Supreme Court to be constitutional. 70 years later, Brown versus Board of Education, those separate but equal laws were found to be not constitutional. So, these federal court judges, they all serve a lifetime appointment in their position. A lot of time a district court will move up into a circuit court judge, higher position, and hopefully a lot of circuit court judges, they hope to be on the Supreme Court someday. But they have to wait for someone to die or resign on the Supreme Court to reach that. They're all appointed by the president, like I said, confirmed by the Senate. It's important for federal judges to serve a lifetime. For these reasons, judges aren't pressured to rule based on their political party. They have their job. Even though they were once based upon their political party, once you reach the Supreme Court level, they have their job. They can be impartial now. They don't have to worry about keeping their job, or in the next case, to be reelected. They don't have to be popular in the public. They have their position. The public can't decide to not elect them again. So unlike a legislator or a president who's really in touch with the people's opinion and what the people really want, the judges really base their opinions on fairness and on the Constitution. And federal judges are expected to judge fairly because they have their position for life. There's no reason to not do that. So they have to have the interests of the nation as a whole while they're ruling. One thing that federal judges can happen to them if they're not doing what they're supposed to do or have bad moral conduct, they can be impeached and removed from their position.